Hello, I'm Edgardo Villanueva, President of E.M.S.I Consulting. Welcome to another version of our feature called Ask the Experts. And today we have a true expert in a field that is of significant importance to employers. And it has to do with the subject of immigration and control and laws in the workplace. Today we're joined by John Hermann. He's the president, CEO, and chairman of the board of a Southern California-based firm known as Form I-9 Compliance. Is that correct, John?
Absolutely.
Okay. John and I have also known each other for many years and have had a chance to work with many different issues in helping management deal with workplace issues. But we want to focus on this rather confusing subject today. And so, John, thank you very much for your time, and I want to just ask you a few questions and ask you to please elaborate. We certainly welcome your feedback and experience. In relation to the issue of your company and its main focus, tell me, when did you first see a need to start your company, I-9 Compliance, and what was its original purpose?
Ed, first I want to thank you for having me on your program, and I want to give my warm regards to your thousands of listeners in the process, and I hope I'm able to provide some value to those people that's practical and useful in immediate takeaway fashion. On November 6, 1986, which is a long time ago, Immigration Reform and Control Act was passed, and from that point forward there was an immediate need for compliance. And as that act was passed, I was in the labor relations area, as I still am with another company, and I started getting hundreds of phone calls asking me for the I-9 form, which the Immigration Reform and Control Act, under its paperwork section, says that you must have. Well, I didn't have a copy of it, and no one else I knew had a copy of it, and I talked to a ton of attorneys, etc. So finally I called the legacy INS, legacy to what's now called DHS, Department of Homeland Security, and asked them to fax over to me a copy of the I-9 form. They said, well, Mr. Hermann, we need to come down and visit you. I said, well, I don't need you to come down and visit me. If you would just be so kind as to fax this to me, I'd be most appreciative. Long story short, they didn't fax it to me. They came down that day. A fellow named, who now works for me some 30 years later, John Brechtel, who was the head of the Southern California legacy INS, and three of his agents with porcupine hats stood at attention behind him, and he said, well, I got some good news for you, Mr. Hermann, some bad news. I said, well, what's the bad news? He said, well, there is no I-9 form. And I said, if that's the bad news, what's the good news? I said, you're not telling me that then President Reagan has passed a law, a very onerous law, which has all kinds of fines associated with it, with no I-9 form for these employers to fill out. He said, well, yes, that is what I'm telling you. I said, well, if that's the bad news, what's the good news? He said, do you have a conference room? And I said, well, yes, I do. And he said, let's go down and create the first I-9 form. So John Brechtel and myself, along with three of his agents, went down and began working on the first I-9 form. It came out finally in 1987. And over the years, there's been really no enforcement, but that has changed markedly. There's been a transition between legacy INS, Immigration Naturalization Service, and the Department of Homeland Security and its sister agency, which is what's called ICE, Immigration, Customs, and Enforcement. Now, ICE is tantamount or equivalent to the police arm of the Department of Homeland Security. The Department of Homeland Security, Edgardo, has 225,000 U.S.-based employees. ICE, its enforcement arm, has 25,000 employees. So over the years, enforcement has taken off. There was a fine just levied for $34 million. The name of the company was E.M.S.I for immigration violations. That was the largest one since 2004, when Walmart was fined, I believe it was $11.4 million for some subcontractors who were found to be illegal. So as enforcement has amped up, the need is amped up for some way to, number one, not create fraudulent or suspect or improper I-9 documents, and number two, to have them perfected. So we created an error-detecting I-9 form, which helps employers and virtually eliminates human error, so they get that right. And then we have electronic connectivity to what's called E.M.S.I. But Ed, I don't want to just ramble on here. Let me turn this back over to you for any more specific questions.
Well, John, I was going to ask you, and you've already touched on the subject of the types of penalties that companies could face for violations of ICE. Besides monetary penalties, are there other consequences that companies could face in the event that they are found in violations of some of these types of rulings, or if their I-9s are not in compliance?
There are not only economic penalties, but I was asked back to Washington for what's called the shareholders meeting or stakeholders meeting in terms of the I-9 and E-Verify. And at that time, Mr. Morton, who's the head of ICE, said, look, we've changed the paradigm in terms of what we're attempting to do. We're no longer interested in simply identifying and deporting those that we find who are illegal. We're interested in going after the employers and their agents, i.e. the supervisors, HR people, etc., arresting them, indicting them, incarcerating them, prosecuting and incarcerating them for knowingly continuing to employ those who are illegal. So it's gone from a monetary situation to now a personal situation where you as an HR director or you as general counsel for a firm, if you know or should reasonably expected to have known that you continue to employ those who are illegal, you have a personal liability. And I think there's a huge difference in an individual having to go home and tell his significant other that, boy, he just had to write a company check for $1 million, which was the case with Abercrombie and Fitch, for example, versus going home and saying, look, not only did I have to write a check for $1 million, but I'm also being indicted personally by the federal government for knowingly continuing to employ those who I knew were illegal. I have a real problem. Now, we have clients ex post facto after the fact that have asked for our services after they received what's called a notice of intent to inspect documents, and we've helped them through that in a very collegial, seamless fashion. And fortunately, we've been able to eliminate or certainly reduce a lot of fines that otherwise would have inured to those employers. But it's a very risky area at this juncture, and it is wrought with pitfalls, not only economic, both civil and criminal liabilities. And I think that's the message the government wanted to get across is, never mind the money, we're going after you personally.
Unbelievable how this has all evolved. John, you mentioned practical advice, and I'm sure you have much of that to share with the viewing audience here. Give us a gist of what should a company do if ICE literally comes knocking on the door? What should they and what should they not do?
Well, once ICE comes knocking at your door, one of my sayings is that it's too late. What employers need to do is proactively do a lot of things so that when ICE does come knocking at the door, they are fully prepared to do what ICE is going to ask them. And here's what ICE is going to ask them. When ICE comes knocking at their door, they are going to be given 72 hours to produce all of their I-9s for current employees, and generally speaking, I-9s for going back about 12 months prior for historical employees. But what the employer needs to do is you want to be on the offensive on this situation. You want to build your firms on concrete versus quicksand, in my opinion. So all of this homework needs to be done, prospectively and aggressively. So you want to have all of your I-9 forms. First thing you want to do is a payroll run to make sure that you have an I-9 form for each and every individual that's employed. Then you want to have your I-9 forms audited. Then you want to put in an electronic system which prevents future human error in terms of the creation of the I-9 form. And then whether or not you're using E-Verify, that there are 19 states that demand some form of E-Verification be performed. And looking down the road 12 months, I'm a firm believer, and this isn't a political remark, that ultimately the Democrats and Republicans are going to agree on at least one thing, which is that immigration reform is necessary, and they may piecemeal it, but there is no controversy between either party that in terms of E-Verify will be the mandate of the land, and it will be the law of the land. Right now we've got 19 states operating differently than the federal government, and that's completely unacceptable. So that's what I see prospectively. And so employers should, one of the worst things you can take a look at here, forget about what ICE can do to you. Take a look at your company itself and the fact that we've had employers that have lost 50% of their workforces. Now, that's a real problem in terms of servicing clients. They're basically put out of business, and that is not good. You want to do things on your own time frame versus on ICE's time frame. So you need, in my opinion, be very proactive in this regard, or you're really rolling the dice with your entire company. A real quick story. There's a sausage factory, which I'll have to go unnamed, up in Northern California, had about 200 employees or somewhere in that general area, and they got a notice of intent to inspect, and I sent one of my people up there, and first thing we did was we got an extension. We cleaned up all their I-9s, et cetera, but 60% of their employees knew they were illegal and went over the fence. I mean, so these people were unable to continue their business, and
yes.
It was extremely costly to that employer. Fortunately, they're still in business, and we got them through the audit and all the rest of it, but not a pretty picture.
Mm-hmm. Yeah, I've seen it myself with some of my clients, John. It's also a human tragedy when people lose their jobs and companies are, as you say, completely thrown off their game plan. One other area that I found, John, that is somewhat misunderstood and misinterpreted, and I know you'll shed some light on this, is many companies, as we both know, use the services of employment agencies to bring in a substantial part of their workforce, sometimes temporary, sometimes even longer than temporary. But if a company hires workers through an employment agency, is that employer shielded in any way from, in the event that worker is not eligible to work in the United States?
None whatsoever. They're even under the thought process of co-employer liability, ultimately in accordance with what's called the M274, which is the employer handbook. You can go online and get a copy of it. M as in Mary, 274. The employer is ultimately liable for all immigration policies and all I-9 forms. So regardless of whether you're using a temp agency or a temp to perm agency, ultimately that responsibility rests upon that particular employer.
Interesting. And the same penalties and consequences would apply, obviously.
Absolutely.
Yeah. John.
We represent a lot of temp agencies, et cetera, to help them refine their work. But regardless of that, ultimately it's on the employer who brings in these temporary employees.
I see. So John, just to kind of get a firmer understanding of this, if a company has X amount of workers that are through a temp agency, should that company then also keep I-9s in the file on those workers?
Absolutely. I mean,
okay.
ICE. There are three situations that precipitate an ICE audit. Number one is the complaint of an employee, current or former employee, that they continue to employ those who they know who are illegal. Another one is where there's a complaint directly to ICE or Department of Homeland Security that from another employer that they are becoming non-competitive because the other employer is paying lower wages because they're using undocumented workers. And the third one are what's called Social Security no-match situations, where the employer routinely gets every year receives no matches from the Social Security Administration, SSA, indicating that the employee's name and his or her Social Security number, date of birth do not match, and those are used as breadcrumbs to the employer's door to identify that must be pursued, frankly, by ICE. And they are pursued by ICE in a very aggressive, straightforward fashion. So ICE has been, over the last few years, kind of, it's a theory of low-hanging fruit, just going after those employers that have, where it's a slam dunk that they know that 50-60% of the employees are illegal without even taking a look at one document. So they'll go up to the janitors up in San Francisco, and I represent a lot of them, and 50 to 75% of those people are illegal. So they'll go to golf courses, they'll go to restaurant, hospitality industry, they'll go to in hospital situations where, in dietary and housekeeping. Anyway, it's the whole system needs to be revamped and done so appropriately. There needs to be a universal, in my opinion, universal law of the land that makes sense for everybody. And within the next 12 months, you'll see that. But E-Verify, people need to be ready for that. And you need to be ready for it because if you lose a third of your workforce, imagine the amount of time, money, effort, energy it takes to restaff, retrain those people. And one final point, Ed, if you're a federal contractor or subcontractor, we do a lot of work with those people, if you're caught using those who are illegal, you will lose your federal contract or subcontract, which means that you are out of business.
Absolutely. One last question, John. I know you have, of course, a very diverse experiences in different aspects of employment and labor law, as you and I know from our relationship from over 30 years. But based on your experience in the labor relations arena, what connections do you see between immigration laws and the National Labor Relations Act for union and non-union companies?
Well, the National Labor Relations Act, the NLRA, there's a particular case called Pacific Steel Casting. And what that says in that case is that the employer, and that's the unionized employer, had the responsibility of advising the union, in this case I believe it was the SEIU, in advance of doing an audit, a voluntary audit, or having ICE come in. And so now all the contracts are being negotiated with that type of language in it. So there is a crossover. Now, Ed, you and I know that, over the years, in the late 50s, about 1/3 of all U.S. working employees were organized by one union or another. We also know that today that number has dissipated down to about 6.4, 6.5% of the private sector employers, and for the public sector employers, about the same number. So we're at about 12.5 or 13% in terms of unionized employees. But I see some real problems ahead in terms of these two ships colliding in the open sea.
Interesting. I think that definitely that will pose additional challenges to our employer. Yeah. Well, John, we want to thank you very much for your time, your expertise that you've shared with us here today. And for those of you viewing this video, if you have particular questions that pertain to your organization, you can, of course, contact us at E.M.S.I Consulting or John Hermann directly, and we'll be sure to have his contact information available to you. So, John, once again, thank you for your time and for sharing your expertise with us today.
And thank you very much for your time, and the kind introductions, the kind words, and for your thousands of employers, I thank you. Take care. And
thank you, John.